Good evening. I'd like to welcome everybody to the November 6th meeting of the Milford Planning and Zoning Board. If you would, please stand for the pledge and a moment of silence. Sue, if you would, please call the roll.
Mr. Agnesi.
Present.
Mr. Alling is excused. Mr. Anderson.
Present.
Mr. Hirsch.
Here.
Mr. Collegian.
Present.
Mr. Macchio. Mr. Mortimer.
Present.
Mr. Sadi.
Present.
Mr. Zahardis.
Present.
Chairman Quish.
Also present. First order of business is executive session. Would like to invite the city planner and the city attorney. So we are adjourned for executive session. Okay, we're back. Thank you for your patience. First order of business is inland wetlands reappointment. Recommendation of the mayor to reappoint the reappointment of Ranjit Bahav to the Inland Wetlands Agency per 18-163 of the Milford Code of Ordinance. Is there someone here to speak to this?
Mr. Chair, no one could be here tonight because we moved our meeting tonight to Wednesday, and that's the Inland Wetlands Commission meeting night. So the Inland Commission meeting is in progress.
Understood. Yeah, I just kind of wanted to meet a little FaceTime, but this is one of our cohorts in what we do. Other than that, I'd hear a motion.
Thank you, Mr. Chair. This is regarding the inland wetlands reappointment. Recommendation of the mayor for reappointment of Ranjit Bahav to the Inland Wetlands Agency pursuant to 18-161 of the Milford Code of Ordinances.
We have a motion. Do we have a second?
I'll second.
Any discussion on the motion?
Mr. Quish, thank you very much. I did read, and I think we all read the letter from, I believe it was Mary Rose Palumbo regarding the reason for the appointment, and I'd ask all the members to approve my motion.
Thank you. Seeing no discussion, would you please call the roll, sir?
Mr. Agnesi,
With the motion.
Mr. Anderson,
I'm with the motion.
Mr. Hirsch,
With the motion.
Mr. Collegian,
With the motion.
Mr. Mortimer,
With the motion.
Mr. Sadi,
With the motion.
Mr. Zaharidis,
With the motion.
Chairman Quish.
I'm with the motion as well. Next order of business is 161 Rutland Road, aka Wilhelm Court, Zone R30, request by Matt Guerra, JP, Guerra LLC, for the release of subdivision improvements and the performance bond granted January 12, 2021, in accordance with the memo from City Engineer Greg Pogluski to David Salkus, dated September 10th, 2024. David, would you just give us a quick overview?
Yeah, so when that subdivision was created, a bond in the amount of $891,496 was put in place to cover all of the public improvements. And as of last month, the city engineer said that $100,000 of it could be released. So that's the recommendation.
Thank you. Without any discussion, I would hear a motion.
Mr. Quish, thank you. Regarding 161 Rutland Road, aka William Court, as Zone R30, I move to approve the request of Matt Guerra, JP Guerra LLC, for the release of $100,000 of the subdivision improvements performance bond granted January 12th of 2021, in accordance with a memo from Greg Godlewski, City Engineer, to David Salkus, City Planner, dated September 10th of 2024.
We have a motion. Do we have a second?
I'll second.
Okay. Any discussion on the motion? Seeing none, please call the roll.
Mr. Agnesi,
With the motion.
Mr. Anderson,
With the motion.
Mr. Hirsch,
With the motion.
Mr. Collegian,
With the motion.
Mr. Machio, Mr. Mortimer,
With the motion.
Mr. Sadi,
With the motion.
Mr. Zaharidis,
With the motion.
Chairman Quish.
I'm also with the motion. Thank you. Okay, next order of business is public hearings, closed by December 11th, 2024, vote by January 10, 2025. Just quick housekeeping. 4143 Dariana Place will be heard before 104 Edgewater Place, so if anybody's timing something, that's information they have now rather than later. First public hearing is 39 Point Beach Drive, Zone R75, petition of Adam Verneau for a special permit for repairs to an existing seawall on map 30, block 635, parcel 3, of which 516 East 78th Street, 4P LLC is the owner. Applicant has the floor.
Hello, my name is Adam Verneau with Ocean County Construction. I'm I'm the owner of a marine construction business. We specialize in seawalls, jetties, piers, revetments, and so on. I'm here today to represent our customer. And what we're trying to achieve is to replace and repair the existing seawall and concrete patio.
And could you give us the address of your business for our record?
The address of the homeowner is at 39 Point Beach Drive in Milford, Connecticut.
And your company?
It is 166 Winterchog Hill, and that's located in North Stonington, Connecticut.
Awesome, thank you. Does anyone have questions about this application? Seeing none, this is a public hearing. If anyone would like to speak to this issue, please come to the podium. Seeing none and without objection, the public hearing is closed, and I would hear a motion.
Mr. Chair, I make a motion regarding 39 Point Beach Drive, Zone R75. I move to approve as presented the petition of Adam Vermalt for a special permit for repairs to an existing seawall at map 030, block 365, parcel 3, of which 516 East 78th Street, 4P LLC is the owner.
We have a motion. Do we have a second?
I'll second.
Any discussion on the motion? Seeing none, would you please call the roll. Sure.
Mr. Agnesi,
With the motion.
Mr. Anderson,
With the motion.
Mr. Hirsch,
With the motion.
Mr. Collegian,
With the motion.
Mr. Mortimer,
With the motion.
Mr. Sadi,
With the motion.
Mr. Zaharidis,
With the motion.
Chairman Quish.
I'm also with the motion. Good luck with your project.
Thank you.
Next order of business is 140 Clark Street, Zone CDD1. Petition of Charles Georgie to amend special permit to add a first-floor apartment created from existing office space on map 53, block 331, parcel 11, of which Nadem M. Ramadan is the owner. Applicant has the floor.
Hi, good evening, Charles Georgie, CGA Architects and Engineers. My office is here at Milford, 365 New Haven Avenue. Here as an agent for the owner. We're trying to amend the special permit to allow an apartment in lieu of the office space. And you could, if you want to bring that floor plan up again. We're actually not doing anything, not adding to the building. We're not doing any changes to the site. What it is the rear section of the plan here, and there's going to be a one-bedroom apartment with a den. There's a separate entrance off of the parking lot and into that. The office in the front will stay. And then below that, you can see the existing office space in the rear. So we're going to be taking down a couple of walls, expanding that bathroom to put a shower and a small washer dryer in there. And in that reception area, we're going to put a kitchen in.
Okay, thank you. David, if you would give us a quick overview and please inform us on the original special permit and why that was part of the original application.
In June of 2021, this property was subject of a zone change that the PZ Board approved from an R10 to a CDD1. At the same time, a special permit was approved to legalize an existing basement dwelling unit. As this is a mixed-use building, the applicant is proposing to amend the current special permit, which is mixed-use buildings require a special permit, to convert an existing first-floor office into a one-bedroom apartment with den. The total amount of residential provided after the conversion is 3,659.5 square feet in a total building of 6,206.66 square feet, which equals 58.9% residential. This is under the 67% residential maximum found in section 3.16.2.1. If approved, the building will consist of a total of 4 apartments and 1 office. There are no exterior changes to the site, which has 15 existing parking spaces.
And the math is still consistent with the zone. Is that what I hear?
Correct.
Okay, thank you. Any questions or comments from the board at this time? This is a public hearing, so if anybody from the public would like to speak to the issue, please come to the podium. Seeing none, without objection, we'll close the public hearing, and I would hear a motion.
Thank you, Mr. Chair. I move to approve, as presented, the petition of Charles Georgie to amend a special permit to add a first-floor apartment created from existing office space on map 53, block 331, parcel 11, of which Nadeem Ramadan is the owner.
We have a motion. Do we have a second?
I will second.
We have a motion and a second. Is there any discussion?
Mr. Chair, I'd just like to know, on the plans, it says proposed two-bedroom apartment, but this is a one-bedroom?
One bedroom, yes.
So that's just a mistake. Okay.
Okay, any further questions? Seeing none, I would hear a motion. We have a motion. I'm sorry. Call the roll, please, Sue.
Mr. Agnesi,
With the motion.
Mr. Anderson,
With the motion.
Mr. Hirsch,
With the motion.
Mr. Collegian,
With the motion.
Mr. Mortimer,
With the motion.
Mr. Sadi,
With the motion.
Mr. Zaharidis,
With the motion.
Chairman Quish.
I'm also with the motion. Thank you and good luck.
Thank you.
Next order of business is the change of order, and it will be 4143 Dariana Place, Zone MCDD, petition of Thomas Lynch Esquire for special permit for a 3-unit residential dwelling where 2 is permitted on map 54, block 322, parcel 14, of which KC Funding LLC is the owner.
Good evening, Mr. Chairman, members of the board. Just for the record, my name is Thomas Lynch. I'm an attorney with the law firm Lynch, Trimbicki & Boynton, and my office is located here in Milford at 63 Cherry Street. And I'm here tonight presenting this application on behalf of Gary and Brian Beer. They're the principals of KC Funding LLC, and they're the owners of 4143 Dariana Place, which is, as we all know, located right around the corner from this building. This is an application for a legal conversion or a conversion to legalize a prior 2-family dwelling as a 3-family dwelling in Zone MCDD. Zone MCDD allows 3-family or multifamily dwellings with a special permit presented to the board, so that's what we're here for tonight. So just a little bit of background. The house was built in 1925. Multifamily uses, 2- and 3-family uses are up and down Dariana Place. I believe the entire street consists of 2- and 3-family houses. My clients bought the property in 2018. They had Jeff Adelino, who's a local contractor, do a major renovation of the building. The upstairs area was part of the 2nd floor apartment, and to be honest, Jeff thought that a 3-family dwelling was a permitted use in the MCDD zone. He got a permit to do the work, and then when he went to get a CO, the assessor's records in the zoning office has the house listed as a 2-family. So that's what brings us here tonight with this application. The house is under contract to sell. It's been fully renovated. There's actually 4 electric meters on the building. There's one for each of the 3 dwelling units, plus a house meter to service the exterior lights. The plans meet all of the zoning standards for the MCDD zone. We did appear before the Zoning Board of Appeals back in August to seek a variance because in that zone for a multifamily dwelling, you need to have a minimum lot size, excuse me, of 5,000 square feet. The lot size of this property is 4,100 square feet. So we did present an application to the Zoning Board of Appeals, and the ZBA did grant that application at its August public hearing. But as I mentioned, all the other provisions of Section 321, 212 are met in terms of the floor area ratios, the number of parking spaces that are required under Section 5143 are met. There's 5 parking spaces on site, And as we all know, this property is located right next to the commuter lot for the Metro North, so there's actually additional parking in close proximity to the building. So it's a pretty straightforward application, and as I said, it's brought to you to legalize the work that was done, converting this to a three-family, but it is in harmony with the neighborhood. It meets all the zoning standards, and I'd ask that you grant this application. Happy to answer any questions if you have them, as well as Mike Sorockman, who is my client's real estate agent, is here with me tonight as well.
Okay, thank you. Are there any questions? Mr. Sadi?
Thank you. Through you, Mr. Quish, to the council. Attorney Lynch, we don't have a building schematic that we normally see with the signs and showing the siding and all that, but it appears that the third, is that the third floor, the smallest unit, is that going?
Yeah, there's 2 bedrooms on each of the first 2 floors, and then the third floor is a 1-bedroom. And we do have floor plans as part of your package. The floor plans are on the website.
We have I have those things, just a 5-page document. Okay. And what's the total height with the building when you add the third floor to it?
It meets the zoning standards. I think it's some 34 feet, but Stephen Harris did review the plans before we submitted the application to the Zoning Board of Appeals, and the house is zoning compliant.
Thank you. The last question I have is the term is used, stacking of the parking. They're not going to be on top of each other, it's just that there's one driveway and there's going to be 3 or 4 cars parking, correct?
Right, and there's a garage that has 2 parking spaces in the rear. Right.
Thank you. No further questions, Mr. Chair.
Thank you. Any further questions? Okay, this is a public hearing. If anyone would like to speak to this matter, please come to the podium. Seeing none and without objection, we'll close the public hearing, and I'd hear a motion.
Okay, 4143 Dorena Place. I move to approve as presented. Petition of Thomas Lynch Esquire for a special permit for a 3-unit residential dwelling where 2 is permitted on map 54, block 322, parcel 14, of which KC Funding LLC is the owner.
We have a motion. Do we have a second? A second. We have a motion and a second. Any further discussion? Seeing none, sir, if you would please call the roll.
Mr. Agnuzzi?
With the motion.
Mr. Anderson?
I'm against the motion.
Mr. Hirsch?
With the motion.
Mr. Collegian?
I'm with the motion.
Mr. Mortimer?
I am with the motion.
Mr. Sadi?
With the motion?
Mr. Zaharidis?
With the motion.
Chairman Quish?
I'm also with the motion. Good luck.
All right, thanks. And Mr. Chairman, so the board does know, the other matter that I had on tonight's agenda, 162 West Main Street, that is going off until the next meeting. I don't know. I didn't hear that at the start.
Understood. Yes, I'm sorry. I didn't say it out loud.
Okay, I just want to make sure you knew that. So.
Okay, yes, we do.
And thanks to Attorney Kisaden and his clients for giving me the advance heads up. So jump ahead of them.
Coffee's on you next time, I guess.
Thanks. Bye.
Okay, so the next order of business is 104 Edgewater Place, Zone R12-5, petition of Kevin Crusading Esquire for a coastal site plan review for a single-family dwelling on map 45, block 513, parcel 39, of which Brenton C. Arts is the owner. The applicant has the floor.
Good evening, Mr. Chairman, members of the board. For the record, my name is Kevin Crusading. My office is at 3 Lafayette Street here in Milford. With me this evening is Brent and Deidre Arts, the property owners and applicants, Ron Wassmer, the project engineer, and architect John Wicko. I wanted to start by highlighting what's happened since we made the last application to the board. During the last application, there were some records in the building department that were not available. They were misfiled under a different Edgewater Place address. Subsequent to that application, over the past few months, I had done some additional research, and with the help of some people in the building department, discovered that there was a zoning permit for the existing pavilion and also a building permit and also a coastal site plan exemption application for that structure and some other permits. So those are part of the record. They've been submitted to the board, but it was for the existing pavilion. The significance of that, and let me just back up. The original application, as you know, was not approved by a vote of 5-4. I had a conversation with the assistant city attorney, and I think it was in the presence of Judge Tima on another motion in that case, about just adding those documents to the record and in the record of that case. And the decision was made it would just be cleaner to come back to the board because the assistant city attorney, Matt Wood's position is that your board didn't have the opportunity to see those documents, so they shouldn't be part of that record. So that's one of the reasons why we're here again filing this application, very similar application. There's just some architectural changes to the house. Also, there was a lot of discussion, and I'm sure there'll be more discussion and claims this evening, that the lot's not a legal building lot. And even though we had presented evidence and we thought was sufficient in the record last go round that it's a legal building lot, we went and we took some additional steps to ratify or reconfirm that it was a legal building lot, and we did that in a couple of different ways. First, we I met with Stephen Harris and talked about the lots, these old building lots. If you can see the plan, there's the 5 old, there they are, yeah, the old subdivision lots. So, as you know, especially, with the previous merger regulation and then the merger regulation that you just enacted a couple of years ago, or reenacted, brought back under 6.4.2, the lots are merged because of the use and because of the structures on the lots. And so your specific language in the most recent merger regulation that was brought back, like maybe a 2023 timeframe, specifically says that the undersized lots will be merged into one lot. The significance of that language is that Milford defines lot in a specific way, and if it's a lot, you can build on it. And if it's a lot that you can build on, you can build anything that's allowed in that zone on that lot, as long as you can meet the setbacks and, unless you get a variance or something. So that was one thing. So Stephen made a decision. This is all happened after the last application. Stephen made the decision that the lots had merged. I published notice of that decision in the newspaper. That's the correct way to do that, to draw out to see whether there's any appeals. The requirement is that a zoning enforcement officer's decision has to be approved to the Zoning Board of Appeals. Within 15 days of in Milford, it's within 15 days of publication of that notice in the newspaper. Stephen's decision that it was merged into one building lot that can be used for any purpose allowed in the zone, as was stated in the notice in the newspaper, was never appealed. And that was sometime in June 2024. Then I went to Mr. Sulkus and talked to him about a lot consolidation, filing a lot consolidation map. So we put together a lot consolidation map that looks similar to the map that's being displayed right now. And that actually is the lot consolidation map. And there's language on the bottom of that map that says that this map is substantially the same as a map that was filed in 2004, which is evidence you had at the last hearing, that showed it as one building lot, or one lot. And so the significance of this is that David Sulkus then signed this map in his capacity as executive chairperson, or executive secretary, of your board. And so by that action, your board has approved this as a building lot already. And that's done under a different section of the Milford regulations that has nothing to do with merger, but it's under that same regulation section. So there's a section in Milford regulations that basically says, regardless of, how the lots were created or who owned the lots or whether there's common ownership of lots. The property owner can combine these smaller lots into a more conforming lot, which is exactly what happened here. Once again, the language of lot is significant because in Milford, lot means it's a building lot. If it's a building lot, you can build anything that's allowed in the zone on that lot as long as you meet all of the other zoning requirements. So and then I published David's decision. I recorded the map and the land records, and then I published David's decision of the lot consolidation in the newspaper. And that decision was not appealed to the Zoning Board of Appeals. So we've taken several steps to confirm what we have known and were told by city officials when we started the process previously. We went back, we heard the comments on the board, we got the denial of the board, but we went back and corrected any potential deficiency that could have existed about whether it's a building lot or not. I would also like to point out that as part of this process, just like the previous process, the zoning enforcement officer reviews these applications as a zoning compliance review. You have that in your package. Stephen Harris has reviewed that. He's determined that the project is zoning compliant, which includes the fact that it's a building lot, because if it was not a building lot, we wouldn't be able to bring the application in the first place. So Stephen also made that decision previously. Lastly, Dave, not lastly for my presentation, but lastly on this point about what's transpired since then, since the last application, David has also, as part of your Section 7 site plan regulations, Mr. Sulkus has certified the project as zoning compliant before it gets to your board. And so he's already made that determination as part of that process that this application is zoning compliant. So what does that mean? So Kevin, so what? Who cares? Well, the reason that's important is because that's been in the record. It was in the record in the previous matter, and that decision has never been appealed to the Zoning Board of Appeals. So there's been about 6 occasions, and I think I had submitted an email to Mr. Sulkus with this, that's also part of the record, where it's been determined by a city official in Milford that the lot's a legal building lot. The Artses have relied on that decision to spend substantial sums of money and change their position in order to build a house, based on the representations from the city officials that it's a building lot. Representations and decisions that that had plenty of notice. Their legal notice has been published, and they've never been appealed. So this board, respectfully to the board, and you have a lot of different authorities, but overturning and a lot of different obligations and authority, but overturning the decision of a zoning enforcement officer is in the sole responsibility of the Zoning Board of Appeals. So by coming tonight, and if you hear comments and from opposition that this is not a legal building lot and you have the right to deny it because it doesn't meet the zoning regulations, that is incorrect. That is what I would call a collateral attack on the decision that it's already been decided it's been a building lot that's never been appealed. So that cannot be considered as part of your determination and considerations for this application. What you're looking at is your scope of review is the house zoning compliant, meets all the setbacks? The answer, according to us, David and Stephen, is yes. And are there any adverse coastal impacts? Mr. Sulkus has opined that there does not appear to be any adverse coastal impacts. John Goucher from Deep has determined that there's no adverse coastal impacts. The city engineer has determined that there's no adverse coastal impacts. Inland Wetlands has looked at this for inland and tidal wetlands and approved it and determined, they don't make that specific determination of no impacts, but they've approved the project. So just to frame it, what the board's looking at is, and so you might be thinking, well, if David certified as it is zoning compliant, so what are we doing here? Why are we a rubber stamp? Why are we even hearing this application? And the answer to that is because statutorily, the CAM Act is not for single-family houses. The CAM Act is a strategic or operational level statute for large projects like power plants or large other operations on the shoreline. The CAM Act actually exempts single-family houses from the CAM Act, except single-family houses that are within 100 feet of a coastal resource. So they remove the requirement for a single-family house to come before your board, and then they pull it back in just to make sure that there's another set of eyes on it, that the single-family house isn't having any negative impact on this project, on the coastal resources. And in this case, it's an existing property that's already developed with other structures, including a dock, 2 properties down from a commercial marina, and 2 properties on the other side from a commercial fishing or oystering operation, shellfish operation. So the stormwater management system, which is now, that's another thing that's changed since the last application, the stormwater management requirements have been made more strict. So there's a 2024 stormwater mitigation from, I'm not sure what the agency is, but whatever the Connecticut State Agency is, that this project was now required to also comply with. So the existing structures and lot do not have any stormwater mitigation or any stormwater management. This proposal has stormwater mitigation. It has stormwater management that the city engineer and the project engineer and DEEP have determined satisfy the requirement. So it's actually going to be in a better situation, and you'll hear from our project engineer in a few minutes. It's actually going to be in a better situation, stormwater management-wise. So that's what we're asking for tonight, and that's what the board is required to look at. And you're going to hear a lot of information and claims, because I know Attorney Green's filed a lot of documents and maps, and I just want to make it clear. This is not a situation where you got rid of 642 and then these lots got certified and now it's a building lot. This is not that situation. This is an entirely different situation. This is a situation where the lots were merged and also consolidated. So really, it's been a building lot since at least 2004, the records will show. So if you just bear with me, I know it's a lot, I know you have a long night, and you already had a long night, and it was a late night for a lot of people last night as well, so I appreciate your time. So I have a memo. What's in front of the board is a coastal site plan application. This is all in your record. I filed it over a week ago, I think, for a single-family house on a single-family building lot in a single-family zone. That is the limited scope of review. It's a legal building lot for the following reasons. We just talked about that. I just want to make sure I didn't miss anything. Yeah, as I said before, neighbors and potentially aggrieved parties, which are usually people that are adjacent or within 100 feet of the property, have had notice of all of these decisions well beyond the 15-day time frame. And I'm talking about the city planner's decision that it's certified zoning compliant. In order to even get in front of this board, we have to go through Mr. Sulkus and he certifies it as zoning compliant. If he doesn't do that, the board doesn't see it. But that's a decision. The decision to merge it, the decision for lot consolidation, Stephen Harris's zoning compliance review from October 10th, 2024, that's part of the record. And then again, the previous decisions that have never been appealed. In reliance on these decisions that the property is a legal building lot, the Artses have changed their position, as I mentioned before, and expended substantial sums of money towards plans, experts, for inland wetlands. We also have harbor management approval and now coastal site plan approval. The city and the board are municipally estopped from now issuing a different decision that the lot is not a legal building lot. So there's no jurisdiction where an appeal is not taken to the Zoning Board of Appeals within 30 days, and in Milford's case, it's 15 days from when the decisions have been issued. And I cite some case law, and some of the cases are attached, and I can always provide the cases if you would like to look at them. The appeal must have been taken within the 30-day time limit. Milford has a 15-day time limit from the decision of the zoning official, and a person who was notified of the decision cannot take an appeal after the 30-day appeal period passed. Okay, great. We know we're not here for an appeal, but what they're doing is a collateral appeal. They're still trying to attack that decision that was already made. Where there is a published notice, like in this case with the two decisions, it must state the certification that has been issued, a description of the building, use or structure and its location, the identity of the applicant, and a statement that an aggrieved person may appeal pursuant to General Statutes 8-7. Those notices are in the record and they have that language. This provision has the positive benefit to a property owner who receives a permit or certificate of occupancy or a decision that you have a legal building lot. It's okay for you to start spending money on an engineer and an architect and an attorney to proceed, and preventing appeals concerning them long after they have been issued. But the publication of a legal notice has the disadvantage of inviting appeals, which might not otherwise have been taken. We talked about it, we took that risk, and we published that notice. As you know, only the Zoning Board of Appeals may overturn a zoning officer's decision, as I said. They were published in June and July of 2024, these notices. I talked about the other thing that has happened is on 94 Edgewater Place, the property immediately adjacent to this property, which is actually 10 feet more narrow and smaller than this property, that this board approved for a coastal site plan application a few years ago. That was appealed by one of the gentlemen who's here this evening. The judge decided that the Zoning Board of Appeals did not make any error in their determination that the permits for that lot should have been issued. So that's something else that has happened since the last application. That appeal has been decided in the favor of the town and in the favor of that applicant and property owner. So this coastal site plan application is for approval to construct a new 2,439 square foot, 2.5-story single family house. The building lot currently consists of docks, a permanent cabana or pavilion on a concrete slab, decking, a gazebo, and an above-ground pool that's temporary. The legal building lot results from merger or consolidation, like I talked about. I already explained that this was not a lot certification 6.4.2 absence in the regulations situation. In here, there is the relevant regulations. So for example, section 7.1.1 of your regulations certified, when the applicant receives all required departmental approvals, the reviewing officer, who is Mr. Sulkus, will then accept an application form and fee and will determine whether or not such application can be certified. This is the language directly from your regulations, i.e., that the proposed building construction and uses are in conformance with all applicable provisions of these regulations. And that's what David's done on 2 occasions now. Neither one of those decisions have been appealed. 6.4.2 as changed. The relevant language on that is 2 or more parcels or combination of parcels, where here we have 5, that abut each other and that do not comply with zoning requirements. Parcel also has a distinct definition in the Milford zoning regulations. It has a different definition than lot, and parcel may or may not be something that you can build on, that depends, but a lot is something that you can build on. So with 2 or more parcels that might not comply with zoning requirements regarding lot size, width, or depth, shall be considered a merged and undivided lot for the purposes of these regulations. There's also another section in the Milford Road zoning regulations under section 6. I was looking at it today when I got, 4 or 5 emails from Attorney Green this afternoon with different documents that talks about when there's a smaller lot or a non-conforming lot like here, you can't use it for any purpose. You can't use it for anything, but you can use it for uses that are allowed in that zone. And this is a single-family zone. So you're allowed to use it for a single-family house. Then I have the definition of lot in here: a parcel of land occupied or to be occupied by a building or group of buildings and accessory buildings, together with such open spaces as are required under the provisions of the regulations. Parcel, any legally described piece of land or any size that may or may not be subdivided or improved. So the old zoning map, the old zoning regulations, the deed, any old deeds that are not even in this, there's no deed restriction in this title change for the past 30 or 40 years. Even if there was, respectfully again to the board doesn't decide deed restrictions. Even if there's clear case law, it's clear Connecticut law that a zoning board doesn't have the authority and that's not within your scope of review, a deed restriction. Having said that, there is no deed restriction. They've owned it for over 20 years, the Artses. There's nothing in their deed that has any restriction on it. I know that there'll be some talk tonight and showing some deed restriction that it's supposed to be used for only a dock and they're in 10-foot strips and so on and so forth. And that references lot 49. So it's not in our chain of title, and I don't have any certified title search or anything, so I'm just going based on the copies that have been provided by opposing counsel. But lot 49, if you look at it, that's a 10-foot wide lot. Even if the board respectfully, again, had the authority to interpret or enforce private deed restrictions, that lot 49 is the top lot. We're not building on that. So it's remaining, you have a 10-foot setback. So we comply with, even if there was a deed restriction, which there's not, but even if if there was, if you look at the facts and most favorable to the opposition, we're not building on it anyway. So we would comply with that in any event. I just want to, there's been filings, a verified environmental petition. Interpleader, I don't know if they're proceeding with that tonight or not. They immediately withdrew it at the last meeting, the last hearing when the board granted a public hearing. I don't know if they're going to do that again tonight or what the plan is. But you don't just take the statutory language and put it in your verified petition, which is exactly what was done with that verified petition for intervention as an environmental pleader. You're supposed to take the statutory language as a guidance, but it's cut and paste. But for this, what they've presented, but you're supposed to take it as guidance, and you're supposed to add what your real environmental claim is. Like, the erosion will cause some kind of damage. And it's not meant to stop projects, and certainly not single-family houses on a developed harbor. It's meant for somebody to say, well, what could be done to address or mitigate that potential adverse impact? That's what it's meant for. It's not meant to, we're going to deny it. So, I haven't seen any evidence of any environmental anything. And like I said, it'll be cleaner, and the stormwater management will be clearer and cleaner once it's in place, that it doesn't even exist right now. Views and vistas. Once again, you have to think about the Coastal Area Management Act. And I think this board really does, because you understand when single-family houses come into this, and I was just here last month on one, and it took 5 minutes. And it was replacing a house with a new house, yes. So, now we're replacing a pavilion and some other things we're proposing with a house. But I think the board gets the fact that it's not like a very deep down digging review with the coastal site plan. Does it comply? Is there any adverse impacts or not? But the Coastal Site Plan Act, once again, is for a much larger project. It's for protecting Connecticut's shoreline in mass so that they don't put a power plant on Charles Island. So that's the scenic view or vista that they're talking about, or that they don't put some type of other business or refining factory over by Silver Sands. It's not an avenue or an opportunity for a neighbor to try to impose a view easement that they don't own, which is exactly what's happening here. These oppositions and what you're going to hear, it's this board, they can stop this project or delay it if they convince this board for, of certain things. They convince enough members on this board of certain things, they can stop this project or delay it. Much cheaper and easier than bringing their own private deed restriction action or bringing their own view easement action. So they're trying to utilize this board as their own hammer. And the board should consider the fact that the Artses have been told from the get-go that this was a legal building lot. I've been doing this for a long time. I would never waste anybody's time or money or the board's time or money, especially my clients. And these costs are substantial. I'm not even going to share with you what the architect and engineering fees are. It's no offense to these gentlemen. That's the type of work that needs to be done in order to do these projects right and to pass the muster of the city engineer and to pass the muster of DEEP and to pass the muster of inland wetlands, which is another expert that they had to pay. The amount of money is substantial. And I would never have brought this, and the Arts never would have just said, yeah, let's just see if it's a building lot and we'll go and spend all this money. They were told it was a building lot. David agrees that it was a building lot. Correct, David? So that's why we're here. So there's no natural erosion patterns that are going to be degraded. There's no view or vista that's being blocked. That's a public vista or view in the context of the CAM Act. It's not, I like to look out over at certain things out of my backyard with a cup of coffee in my hand, and now I'm not going to be able to do that anymore. That's not what this statute is designed to do. So I've listed everything that I've put in the record. I hope you've had an opportunity to review it. We reserve the right to respond to the intervener environmental petition and whatever comments come from the opposition this evening. I just want to see if there's anything else because there is a lot of information in here. I've given you the case law on some things and published notice. And neighbor's view is not a coastal resource. This is a specific case. A neighboring property owner's view across a parcel of coastal land is not a coastal resource under the statute. And the Zoning Commission did not have to consider it when reviewing and approving a coastal site plan for a special exception. That's Bryan versus Branford Planning and Zoning Commission. It's a Connecticut law reporter case. It's not an appellate court case, but sometimes the appellate court takes cases, sometimes they don't. Degrading visual quality through significant alteration of the natural features of vistas and viewpoints, which is a claim that I've seen in a recent letter from Attorney Green, that's an example. New construction that significantly obstructs coastal views from a scenic overlook or a public park. That's not what we have here. So once again, project's zoning compliant. Water-dependent use, that's another claim. It is a water-dependent use. There's docks there, and they're staying as docks. You don't have to, have a marina in order for it to be a water-dependent use. That's exactly, and now it's going to be a house with docks. The property will actually be more zoning compliant with the current regulations because of the fact that right now, in the current zoning regulations, the docks would be an accessory use. So right now they wouldn't, right now they're a legal pre-existing, primary use or principal use. So with that, and Dave, do you mind if I just want to show some pictures and then I'll be done. Thank you for your patience. Just have some case law. This is just a memo that's part of your record. I just wanted to see if there's any questions or comments on not sure if this is the oh, that's the intervener position. I apologize. This is the memo that I just discussed or ran through. And so I just wanted to show this. Here's one photo of, let's scroll down a little bit. Not sure what that is. So this is the highlighted yellow is 104 Edgewater Place. You can see the pavilion on there. You can see the docks. You can see another, like a gazebo looking material. Adjacent to it is 94 Edgewater. There's a house there now. And Mr. McKenna's house, 24 Rose, is over here. So it's diagonally across the public right-of-way. Here's a property. It's got a pizza oven there, he's got an in-the-ground pool, he's got a couple of docks. Here's Spencer's Marina down over here. Now there's a house here. Here's a commercial oystering business, and then down the end of it is Dr. Open's house, and then Oyster River. This is the deed of the Artses. There's no deed restrictions here. It says conditions and agreements set forth in a stipulated judgment, which I've given you. Which I'm glad I looked at this, because the stipulated judgment talks about Edgewater Place, and it talks about it, who has to improve it. There was some, years ago, there was some arguments amongst the neighbors about access, and so it's a city public street that the city's not going to improve. If one of the neighbors wants to, one of the owners wants to improve it, they can improve it at their own cost, which is why the city engineer is not requiring us or anybody to pave it to the 50-foot width, which nobody, or put sidewalks in, which I don't think anybody wants. The significance of the stipulated judgment is that these lots, this lot is referred to as lots in the stipulated judgment that is signed by the mayor back then in 93 or 97, 98, whenever it was. So once again, it's been determined it's been a lot. This is just some information from DEEP about adverse coastal impacts and what's considered, what you're really looking at. And this is the example I read to you: degrading visual quality through significant alteration. That's new construction that significantly obstructs coastal views from a scenic overlook or park. And here's some other examples of things that DEEP gives as examples on a larger scale, or what they consider important. And that is not what we're talking about here. I just scroll down and then I'll be done. This is just more language about coastal resources, Brian v. Brantford case that I read to you, or portions of it. You've had all of this information. So this is the old 642. Let me go back here, because this is how the lots were consolidated. Even though they were consolidated in 2004. Section 6.4.3, notwithstanding the provisions of 6.4.1 and 6.4.2, vacant, non-conforming lots may be combined to reduce any non-conformity with respect to lot size in accordance with Section 2.3.1 of the subdivision regulations, which is the actions we took since the last hearing. Mr. Sulcus, as the executive secretary of your board, consolidated it as a building into one single building lot. Here is your new merger regulation. I already went over that. That says it shall be combined into one lot. Once again, lot means building lot in Milford. Here's the old, I just had this in there because I had it last time. I'm sure you'll see additional things. I just wanted to point out, just as a frame of reference, 24 Rose Street, diagonally across the public right-of-way from here, originally itself was a bunch of little lots, and it was also undersized for the zone back then. So, this happens all over Milford. In the wetlands approval, city engineers approvals, we have all that. Deep approval, we have all that.
I'm sorry, it's just being redundant is not helping your case, for me personally.
Yeah.
I just feel like you said the same thing 4 or 5 times. I get it. I think we all do.
Okay.
And I think that if, in fact, you want to help your client, I think you would not continue to be redundant.
Okay. So there we have, this is the Stephen Harris's decision. I'm just pointing out in the record, so if the board members would like to look at it, where it is. This is the lot consolidation map. And let me just see if there's anything else. And thank you, Mr. Chairman, for your comments. These are the old permits that I talked about. I just want to point them out that they're in the record for your review. This is some other photographs, once again, showing the area and the developed nature of the neighborhood in general and the developed nature of the harbor in general. That is 24 Rose Street, and oh no, that's not 24 Rose Street, that's the house next to it. This is just more there. Let me just see if there's anything else. Other pictures of the developed harbor. I just want to make sure that if the board members haven't had time to look at these photos, that before you make a decision, you take a look at the exhibits that were attached to this memo. That's why I wanted to run through it, but I thank you. And I'm pending your questions. I'll be followed by John Wicko.
Do we have any questions at this juncture?
Thank you. Through the chair to you, Mr. Crusaden, we've got hundreds of pages of material that we're looking at. And I've looked at the interveners' documents. There's a lot of materials there, but are you aware of any reports? We have a hydrology report from Mr. Wasmer, but any other reports that deal with the issue of polluting of the waterways of Milford Harbor, or any reports regarding the air, or any reports indicating that would affect the resources of the state of Connecticut, either in your moving papers or anything from the intervener?
No, I'm not aware of any other reports.
And it appears you've done a very good job of looking through all the papers that are available, so it's fair to say there's nothing to support the claim of the intervener by way of any report. Is that fair?
I would agree with that, yes.
Thank you. No further question at this point, Mr. Chair.
Attorney Crusaden, good evening.
Good evening.
Can you show the deed again for the property? Can you go back to that?
Yeah, I don't know, Dave, if I can, sorry. Try to just zoom up to it here. Was it this or the legal description you wanted to?
Is it your position, Attorney Crusaden, that this has been a legal building lot since 1924?
It's my position it's been a legal building lot since at least 2004.
Since at least 2004?
2004, when building permits were issued for it, for the pavilion that's there.
Thank you.
Yeah.
Any further questions at this juncture? Not? The architects, welcome to.
Good evening, Mr. Chairman of the Board. John Wicko, architect at 58 Prospect Street in Milford. I'll speak about SP1, which is the first site plan sheet, which has a zoning data matrix on it, which describes the requirements of the zone, the existing conditions with the buildings on them, and the proposed building, which we are presenting tonight. It's in the 12.5 zone, single family, 2,400 and change square feet on a lot of 5,010 square feet. The footprint, thank you, David. The footprint itself meets all the setbacks and zoning criteria as described in the matrix and delineated on the site plan. The setbacks, one of them that we're conforming to is the 25-foot development limit, which the deck is up against, and we're within that from the mean high water. We've got our side yard setbacks conforming. We do have projections into them which are allowed, which are described. We are using the existing gravel road driveway and the road that's coming in, the private right-of-way, with no changes for the vehicular access. And the zoning matrix also describes that we're meeting the building area and lot coverages. Other site plans, which Ron Wasper, the project engineer, will go over. And next is the building itself, which is a straightforward zoning compliant and FEMA compliant structure with the foundation on the F1 sheet, which shows 2 cars that are going to be parked under the house with one 16-foot door, elevator service to the first and second floors. The foundation material is poured concrete, which extends out of the base flood and design flood elevations, and that'll be clad with a thin stone. So all compliant with the materials that are required for FEMA. The floor plans describe the living areas, the kitchen, dining, and living room with powder room and laundry, all the normal things that the artists are excited to enjoy when the house is built. Decks and balconies. Second floor houses the bedrooms, bathrooms, closets, all the typical stuff for a nice single family house of this size. There's also a third floor, stair to the third floor finished attic, which has an office and a living area and access to an observation deck. That's a flat deck within the roof. That deck also is a location for the mechanical equipment and whole house generator. Elevations, you can see the rendered stone on the concrete, and then a vinyl shingle material for the siding. Shows the overhead door, the balconies, paneled trims and architectural details. That's nicely assembled and designed. Building height is under 35 feet. We have the dormer for access to the roof observation deck is over, and we are using the dormer exemption, which on the last sheet, which is building sections, has my worksheet that describes the percentages that meets the regulation. That's a quick overview of the building. Certainly be available to answer questions now or after when you're
Thank you.
develop those.
Any questions for the architect at this moment? Yeah.
Thank you. Through the chair to you, Mr. Wicko.
Yes,
Good evening to you, sir.
thank you.
A little bit about your background. How long have you been doing this for, please?
30, probably 7 years.
Fair enough. And how many of these 37 years you've been involved in CAM applications?
Oh, I would say a good 30.
And
Successful buildings, yep.
looking at the building, seems to look really nice, but for example, is there expected to be an air conditioning unit or units
Yes.
in the building? And where are those going to be placed? Are they going to be on this first floor, 15.6 feet high?
We have one mechanical condenser that's hung from the side of the building. That's delineated on the elevations, and it's, I don't remember, I think it's 13.8 feet is the bottom of the platform, the equipment itself. And then there's, as I described, there's generator and a condensing unit on the roof.
Again, it appear to be that
Above.
they're going to be elevated is the point.
Elevated and out of the base flood.
Heating
design.
system,
Yeah.
is that going to also be elevated?
Yes, everything's above the design flood elevation. All
And
mechanical.
based on your work that you've done over these years, do you have any opinion that the design that you made for the applicant would have any ability to affect and unreasonably pollute the air and water based on the design that you made?
No, the units are electric, so it will have no exhaust.
Thank you, sir. No further questions.
Thanks.
Thank you. Any further questions? Seeing none, you guys can continue your presentation.
Sure, Ron Wasmer.
Good evening. For the record, Ronald Wasmer, professional engineer and a land surveyor with an office at 158 Research Drive, Milford, Connecticut. I'm here representing Brenton Arts, the property owner for the coastal site plan application at 104 Edgewater Lane. My role as part of this team in submitting this application is the surveyor, preparing the existing condition surveys as the basis for the site plan and as the site engineer to prepare site engineering in regards to stormwater management, utility location, erosion control, and I also assisted in preparing the coastal site plan application. I'd like to briefly review the coastal site plan application and the plans. I'm going to start with page 1 of the application, which is part of your record. The type of project is a single-family residence. The coastal resources located within the project or with the project or which the project will affect. The coastal resources that are on the property are the general resource, tidal wetlands. There's approximately 59 square feet on site and additional tidal wetlands adjacent to the property. A coastal flood hazard. The parcel is located in flood zone AE11. Coastal resources, the coastal waters. The parcel is adjacent to Milford Harbor. Coastal resources developed shorefront. The parcel is designated on the coastal resource map as a developed shorefront. Freshwater wetlands are adjacent and fall within the municipal right-of-way for Edgewater Place. On page 2 of the application is the applicant identification. The applicant is Brenton C. Arts, 9 Nair Lane. Section 2 is the project site plans. The plan set contains the information requested in the application. It consists of a project location, the existing and the proposed condition, including buildings and grading, the coastal resources on and contiguous to the site. The high tide line is defined by Connecticut General Statute, soil and erosion controls, stormwater treatment practices, ownership and type of uses on adjacent property, and a reference datum. In this particular instance, the reference datum is the National Geodetic datum of 1983, which is the datum that is used by FEMA in determining flood zones. Section 3 is the written project information. The planning and zoning staff has determined the site plan is zoning compliant as listed in section 3 and by the staff review, including with the application. Continuing with the application, the part 1 is the site information. The application provides the information requested for street address. The project is a waterfront site. The coastal resources, the adjacent coastal waters are the Milford Harbor. The existing site is a residential zone parcel and is used also as a private boat facility. The project site is approximately 5,011 square feet. The project will not disturb 1 acre of total land area. The project is not a shoreline flood and erosion control structure. Part 2A, description of the proposed project activity. The proposed redevelopment is for the construction of a single-family residence. The site currently contains a building with a deck, a gazebo, a dock, a gravel driveway, and gravel parking, and some lawn areas. There will be no clearing on the site. There will be de minimis grading of the site upwards of the high tide line and no grading waterward of the high tide line. The existing gazebo and buildings are to be demolished. There will be an increase of impervious cover. Existing impervious cover is approximately 17%. The proposed impervious cover will be 39.2%. The single-family structure is in the vicinity of the existing deck and the existing gazebo. The residential nature of the use of the site will not change. The site will continue to be used as a parking lot for a boat dock and as a boat dock, and now will include a single-family residence. The site is an existing residentially zoned lot. The proposed single-family residence will be located in the uplands. If approved, the building is scheduled to start in the spring of 2025 and to be completed by the fall of 2025. The proposed single-family residence is going to be constructed with a concrete foundation and timber frame. The site will continue to be a water-dependent use for a private boating facility owned and used by the applicant. The existing ramp and boat docks are to remain as they currently exist. Part 2B, description of the proposed stormwater practices. The current stormwater best management practices will be employed. There's currently no storm drainage or water quality features on the site. The water quality volume as defined in the 2024 Stormwater Quality Manual is provided through infiltration trenches. The storm drainage is also designed per the City of Milford requirements for a 25-year storm of 24-hour duration. Sedimentation and erosion control features are depicted on the plans. The roof drains will be directed towards the infiltration galleys. The site is quite flat. The majority of the site drains towards Edgewater Place, away from the tidal wetlands and towards the freshwater wetlands just off-site in Edgewater Place. The proposed improvements to the parcel will include stormwater management and sedimentation and erosion control. The stormwater plans were developed in coordination with the Milford Engineering Department and Connecticut DEP Land and Water Resource Divisions. There are statements supporting the plans from Greg Pedlewski, City Engineer, and John Goucher, Environmental Analyst for Connecticut DEP. The proposed stormwater management was previously reviewed with the City Engineer with the application to the Milford Inland Wetland Agency. Specific features include roof drains, which will be directed towards a hybrid bio-retention infiltration trench. The proposed driveway will be resurfaced with clean broken stone. Broken stone surfaces provide the ability for stormwater infiltration and results in water quality improvement as compared to paved surfaces. An infiltration bed will be installed with the proposed broken stone parking area. The broken stone and the infiltration bed, as well as the nearby freshwater wetlands, also provide effective removal of pollutants, resulting in improved water quality over the existing conditions. The runoff of larger storms follows the current drainage patterns towards the municipal drainage structures in Edgewater Place. Part 3, again, somewhat redundant, but as part of the application, is identify of coastal resources. As previously stated, the on-site, adjacent, or off-site, but within the influence of the project are the general resource, coastal hazards, coastal waters are adjacent to the property, a developed shorefront, freshwater wetlands are on adjacent land, and tidal wetlands. Part 4, consistency with applicable coastal resource policies and standards. This redevelopment project is consistent with the coastal resource policies. The project will preserve the coastal resources. There will be no adverse impacts to the general resource. The proposed single-family house will be built with no impact to the coastal hazard areas. The single-family residence will be constructed following appropriate building codes as required by the City of Milford Building Department and coastal flood hazard requirements per Milford zoning regulations. The main floor is elevated 4.6 feet above the base flood elevation of FEMA flood hazard area. There are 5 engineered flood vents to provided in the enclosed area. The enclosed area will be used as a garage, a storage area, and main floor access. There will be no adverse impacts to the developed shorefront. The existing riprap, ramp, and dock are to remain. The site will continue to be a water-dependent use as a private boating facility owned by and used by the applicant. There is an existing ramp leading to the dock, and there are no proposed changes to the existing ramp or to the dock. There will be no adverse impacts to the tidal wetlands. The project does not encroach into or degrade the tidal wetlands. There will be no adverse impacts to the adjacent freshwater wetlands. The project does not encroach into or degrade the freshwater wetlands. There will be no adverse impacts to the adjacent coastal waters and estuary abatements. The house will be connected to the existing municipal sanitary sewer. The proposed redevelopment will not change the essential patterns of circulation, drainage, and basin configuration. The site grading is upland of the high tide line, and there is no proposed fill or grading waterward of the high tide line. Sedimentation and erosion control measures and stormwater treatment measures are indicated on the plans. Grading will be substantially similar to the existing grading patterns. Vegetation will be restored in certain areas to buffer against risks of erosion. I also want to add that the new structure is resilient to the coastal flooding, more resilient to the coastal flooding than the existing structures. Part number 5 is the identify the coastal use policies. The coastal use policies applicable to this project are development, general development, and water-dependent uses.
So just so you know, we did all read this already. You're not anticipating you're telling us anything new. This is what we have, and we've all read it. So
I'm making it part of the record.
that's fine. I mean, it is already part of the record. And if, just let you know that...
I'm getting close.
That's fine.
Another use is boating. Consistency with the coastal use policies and standards. This redevelopment project is consistent with the coastal use policies. The project will preserve the water-dependent use for recreational boating. The site will continue to be used as a water-dependent use as a private boating facility owned by and used by the applicant. The land is zoned residential per the Milford zoning regulations. The proposed single-family residence will be located in the uplands. The existing boat ramp and boat dock are to remain. There is no proposed filling or grading waterward of the high tide line. There will be no adverse impacts to the tidal wetlands. The project does not encroach into or degrade the tidal wetlands. Part number 7 is to identify potential adverse impacts. No adverse impacts have been identified with the proposal. Part 7B is to identify potential adverse to the water-dependent use. The site is historically and currently being used as an active water-dependent use as a private boating facility. The existing boat ramp and boat dock are to remain. There is no public access. The scale of the project and the project location does not support meaningful public access. Public access to adjacent coastal waters are located nearby with amenities to support public access, such as parking areas and a boat ramp. Part 8 of the application is mitigation of potential adverse impacts. There are no proposed adverse impacts identified, and therefore no mitigation is proposed. Part number 9 is remaining adverse impacts. There are no remaining adverse impacts. I'll be happy to briefly review the engineering plans in regards to grading or drainage, or if you've had a chance to look at them, I don't need to do that again.
Are there any questions from the board at this time? Mr. Staddy.
Thank you very much, Mr. Chair. Through you to Mr. Wasmer. Would you give us a little bit about your background? How long you've been practicing?
I began working in 1985. I became the principal of my company in 1993. I've worked in Milford since 1985 and been the
Fair
principal
enough.
of an
And
engineer.
in the time frame since 1985 to present, approximately how many coastal area management applications have you filled out? Give us your best estimate, please.
50, give or take. 50, give or take.
Okay. You indicated in the actual document that we have seen and you read to us, you found no adverse impacts to the coastal resources. Is that accurate?
Yes, that is.
So therefore, you would agree with me there, you found no way that the proposed plan and the proportion that you took part of it would not degrade the natural erosion patterns of the area. You would agree with that, correct?
Correct.
And therefore, there'd be no unreasonably polluting of the, or impairing of the air nor water, correct?
That's correct.
And likewise, there would be no unreasonably polluting or impairing any other resource of the state of Connecticut, correct?
Yes.
Now, you talked about Mr. Goucher, who works with Department of Environmental Protection, and there was some back and forth. We've seen hundreds of pages, but some back and forth, and this has to do with downspouts, so they wanted you to do some other testing at the end. Are you familiar with that?
Yes.
Could you just briefly explain that to us, please?
He asked us to substantiate that certain soil drainage characteristics would be installed adjacent to the downspouts, and that he asked me to confirm that at the end of construction.
Okay. And again, this is to further make sure that there'll be no adverse impact to the coastal resources in the area. Is that correct?
That's correct.
I have no further questions, Mr. Chair. Thank you very much, Mr. Wasserman.
Thank you. Any questions at this time? Yep.
You mentioned vegetation will be restored in certain areas to buffer against risk of erosion. Could you explain which areas you're talking about there?
In the upland area of the property, we're going to be constructing a house, so there'll be heavy equipment. There's no beach grasses per se on the property. There's lawn grasses, some flowering shrubs. Anything of these that get damaged will be restored through landscaping.
So you're just talking about basic lawn?
Yes.
Okay, thank you.
Thank you. Any further questions at this time? Okay, thank you.
Thank you.
So without objection, we'll go to the public hearing. And again, this
Jim, if I could interrupt for a second. This is a new application?
Yes, this is a, yes.
So ordinarily, we don't turn CAM applications into public hearings. Last time we did, I'm not sure we gained anything from it, but I think we should at least, at a minimum, take a vote whether we want to turn this new application into a public hearing. Because CAM applications come before us all the time, and we never, ever have public hearings.
Very infrequently, you're right. I think we did have a vote on having this be a public hearing, and it was in the affirmative.
Yeah, that was at one of the prior meetings, because we then advertised it.
So again, it is a public hearing, and it was on our discretion. So this is not a courtroom. This is not a long exercise in an argument. As with all public hearings, you'll be invited to speak. You'll give your name and address. For the record, you'll be allowed 3 minutes. If someone comes up and wants to say that they agree with a previous speaker, please do that instead of reiterating or being redundant, which will probably not help your case. So if anyone would like to speak to this issue, they are welcome to come to the podium, and please keep your comments to about 3 minutes.
Good evening, Mr. Chairman, Board. My name is Gary Montano. I live at 24 Founders Way, which is and 94 Edgewater, next to the Artses, which is the property, my property is with a single-family home. The Artses property is actually 50 by 100 change. Mine's 40. I am here this evening in full support of this application and ask you to approve this application this evening. The Arches have the support of the city, the mayor, Mr. Selkis, Mr. Harris. Like you and I, the Arches are longtime tax-paying residents. They started this project after they confirmed with the city that the project was legal. I'm not going to repeat. Approximately 4 years ago, I came before you at the 94 address, and you granted me a home to be built, subject to certain things. I'm happy to tell you that I have my COs and CZCs. I respectfully say enough is enough with the constant appeals, harassment, and costs. The board should approve this application tonight. The work of beautification to this harbor complements the Arts, myself, and the 2 adjoining parcels that I bought in the last year. I now have close to 85 feet, of which started at 40. Most recently, the DEEP with the U.S. Army Corps have approved a new bulkhead and docks. I thank you for your time. Also, for the record, I'm on the Zoning Board of Appeal. Thank you.
Thank you.
evening, Mr. Chairman, members of the board, staff, the public. My name is Joel Green. I practice law in Bridgeport with the law offices of Green and Gross. It's my pleasure to appear before you this evening on behalf of Chris McKenna of 24 Rose Street. I have brief comments. We have filed a petition to intervene. We will present on these items, and I will be brief this evening. I have to make a couple of quick comments. The chairman is correct. This is not a court of law. There have been a number of claims made by the applicant that have nothing to do with the jurisdiction of this commission in acting on this CAM site plan review. The fact that the applicant has spent substantial sums in theoretical reliance in some sort of estoppel argument, it has nothing to do with this commission's CAM review and is inappropriate, violates the rules of fundamental fairness and natural justice which govern the actions of this board. Equitable estoppel or estoppel is a principle of law used in courts of equity. And if you're unfamiliar with it, it's because it has nothing to do with zoning commissions exercising their jurisdiction under an application such as this. That's item one. Item two, there are deed restrictions involved here. Council is correct that it is not the job of this commission to interpret deed restrictions as part of this CAM review. However, the applicant then made a comment that they are not constructing anything on lot 49. Well, how do they want it? Are the lots merged or are they not merged? If the lots are merged, then they are constructing something on this merged lot. So that's the next item. What happened here, and I provided you with title information that goes back to the inception of these lots in 1927. Lots 45 through 48 were in one set of ownership beginning in 1927. Lot 49 was separate. They were not merged. And you can see in the title information I've provided, this lot did not come into being as lots 45 through 49, consisting of a 50-foot wide lot until 1979. When these lots were formed in the 20s, and when your zoning regulations were adopted, you had to have a 50-foot wide lot. You had to have a 50-foot wide lot to establish a building lot on the property. I've provided you with the 1930 zoning regulations. You needed 6,250 square feet. These parcels, 45, 46, 47, and 48, were only 40 feet wide and were only 4,000 feet. So in 1930, when your zoning regulations were established, this was not a building lot. It did not meet the regulations to be a building lot. At that time, you could create a dock, you could create a shed, you could create something related to the use of the water. As you are aware from having seen this application before, there were 79 10-foot wide strips of land to provide water access to the 79 upland lots behind it. These 4 lots did exist as a parcel beginning in 1927 when that Walker Manor map was recorded. They were never a residential building lot, and they were used as a dock and as a shed and uses related to that. The regulations were subsequently amended in the 50s to provide that you could create a dock or a shed or that sort of thing by special permit. There was a pre-existing dock use on this property and pre-existing some other structures on the property related to the waterfront. In 1979, based on the documents I've provided you, these lots were finally assembled as a 50-foot wide, 100-foot deep lot, 5,000 feet. At that time, and I've provided you with the 1978 and the 1979 zoning regulations, you had to have 12,500 feet of area, and you had to have an 80-foot wide lot. So when this lot, this merged lot, or whatever you want to call it, parcel, 5 parcels, or 1 parcel that's 50 feet wide, never qualified as a building lot. It never met the regulations that were adopted by the city in terms of area and in terms of width. 6.4.2 speaks specifically in each instance, 6.4.1 and 6.4.2. The first qualifier for use of either one of those regulations is, and that the lot was of legal size when it was created as a lot. And that simply never happened here. This has never been a lot, a building lot, that met your zoning standards. So 6.4 is out the window in terms of this property. This game of sort of gotcha with these sign-offs in the past, please review the documents, because what you'll find is, and I've provided you with the documents, and respectfully, I am going to move quickly, Mr. Chairman, based on your caution, but this is important and I think will help the commission. In May of 2004, there was an application for a building permit to create a tent, a recreational tent. I have provided you with the material. The present use of the property is, quote, for 4 boat docks. This was added as an accessory use. So a tent accessory to these boat docks in 2004, in May of 2004. And in fact, on the City of Milford, the building inspector, and for the coastal site plan review, it specifically X'd the box that said, additions or modifications of existing buildings or detached accessory buildings. And it says tent. The box that says new residence, single-family home, was not X'd. It was never the intent to create a single-family home in May of 2004. After that, there was an application to create a gazebo-like structure, and I have provided you with that material. And similarly, same thing. There, the applicant said that it is accessory. And in fact, the use group was accessory structure, and this was in the fall of 2004. And there is, it says marina, vacant lot, create a 12 by 20 pavilion, gazebo. And once again, it references specifically that it's accessory. And yes, that was signed off on. So for the applicant to suggest somehow that in 2004, this was established as a building lot for all purposes under your zoning regulations is false. It is untrue. Similarly, for the applicant, and in comments in court and in certain documents in this case, has suggested that I don't understand how things work in Milford and I don't understand the regulations. All I can do is read the regulations. So to suggest that the fact that council, as he has suggested, had meetings with Mr. Sulkus and Mr. Harris and got them to render opinions, and the fact that they said that it is a, quote, building lot, and then to publish that in the newspaper and claim that we are now stopped. We cannot appear before you and question that because it's been approved as a building lot is false. It's false because those opinions are not appealable. They are preliminary at best. Who approves site plans in the city of Milford? You do. It is not staff that approves site plans. And the law, case law in Connecticut is clear. There is the Reardon opinion.
I'm sorry, we're not going to go into case law.
I'm just saying.
Yep, okay. I mean, we've given twice the 3 minutes, and we're going to open it up if anyone else would like to speak. If after other people speak, and the applicant will have an opportunity to address that, you'll have another opportunity. But we're not going to just continue this as if it was a court case. So anyway, if anyone else would like to speak.
You're not going to let me speak?
I did let you speak, and the rules of this commission, this board, is that in a public hearing, you're allowed 3 minutes. I've given you at least twice that.
Well, I'm not finished with my presentation.
Well, that's all right. I mean, it's not my fault that your presentation was longer than what our rules say, so.
Well, under the law, I have the ability.
I don't think that that's going to be the best way for you to go, to start telling me under the law you have a right to be here. You do not. So
My client is a party to this proceeding.
your client can go to court with you, but not here. So that's the final decision.
So, Mr. Chair, just to make it clear, because he probably didn't hear you say it, because I heard you say it, that after the other people have their chance to speak, he can come back and finish his presentation.
I did say you could come back, and
Yes.
the 3 minutes
After?
will still apply. Another 3 minutes. Those are our rules, David. And I have been and will be, give a little bit of leeway.
Okay.
So if anyone else would like to come up and speak, now's the time to do it.
Good evening. My name is Joseph Newman. I live at 23 Wilbar. I will keep my comments brief, I promise. The one thing I'd like to address is the characterization of Mr. Montano and counsel.
Please address the court.
Sure.
Don't address the applicant.
Well,
And
sure. So they've insinuated that our complaint is harassment. And would like to point out one fact. All of the people sitting on the other side of the aisle are not neighbors of this property. They are people who live near the area, who are familiar with building a house like that is going to do to the nature of Gulf Street, our neighborhood, people who live on the other side of the harbor looking across. If we start filling small slivers of property with large houses that are disproportionate to what exists, the character of our harbor is going to change irrevocably. It may not happen with this application or the next application, but if we keep going down this road, we're going to lose what makes Milford Harbor special, both on our side of the harbor and on the other side of the harbor. So I'd like you folks to keep that in mind, because Milford is changing, and is changing rapidly. What kind of town do we want to be? And that's the question ultimately that you have to decide. Thank you.
Thank you.
Hi, I'm Matt Paterna, 57 Harborview Avenue, Milford. 30-year resident. I've lived in the neighborhood for 20 years now, and when I moved there, it's a quaint neighborhood. I'm sure all of you are familiar with it. You've been down there. It's it's a bit of heaven. You go to the end of the street and you see this beautiful tall grass, and wildlife, foxes, bunnies. My kids play down there. My cats and dogs run around down there. I'm not an attorney. I don't know the law. I'm not here to debate the law. I'm just kind of here to kind of make like a common sense understanding of what's going on here. And I think about like 1920, when this neighborhood was like kind of established, and they had these lots, and the idea was to have a right-of-way for people who own property in the area to get to the water and enjoy it. And they parceled off these rectangular spaces, from what I understand, for the purpose of getting to the water. And on paper, it's a lot. On paper. I don't think the intention of those lots was to then all of a sudden start building structures on it. Granted, you built a nice structure. I'm not arguing that it's a nice looking structure. I just don't necessarily think that it was the appropriate place for the structure, given the intention. And I always go back to that. Like, what was the intent of those lots in the first place? Was it to one day, 100 years later, decide that we're just going to go ahead and change what was supposed to be just a natural area for animals and for people to kind of hang out at? And now we're putting up structures, and now that we have a small structure, and now we got a larger structure going. What's next? So that's all I have to say about that. Thank you for hearing me out.
Thank you.
Hello, my name is Regina Sirico. I live on Wilbar Avenue, 61 Wilbar. I've been a resident of Milford for about 45 years. Closer, a resident of Milford, 45 years. I I would suggest that you walk that property. Everyone talks about it being upland. It is not. It is lowland. Everything to the west of Edgewater Place is lowland. It's wetlands. It was never meant to be a building area. And I would hazard a guess that emergency services, if they're ever needed down there, with electricity in the water or high water, that you're creating an issue of not being able to get to those residences. I just don't understand. And I just wanted to let you understand that there's many concerns, and I don't see that you see it. Thank you for your time.
No, thank you.
My name is Chris McKenna. I live at 24 Rose Street in Milford. I've been a resident there for about 20 so years. Just want to quickly review this map. If you look here, the map was recorded in 1924. It's the map of Walker Manor. All the houses on the upland are actually have a number. They go from 1 to 79. All these were maybe a little bit smaller lots, but they were on the map in 1930 when the regulations came in. These are all deeded. They're called Lot B. They're all tied to one of the lots on the upland, and they're all called parcels on their original deed. You'll see that in the deeds that we sent. There never were building lots. There are 10-foot strips, never building lots, and you could merge 5 of them together, and you just have 5 merged lots that don't qualify for a legal building lot. It's a 12.5 zone. If they want to build down there, they need to get 13, and then it'd be a legal building lot, and they can do it. But if you could merge 5 lots together, that does not make it a legal building lot. So that's all. Thank you.
Thank you. Is there any other comments from the public? David, one second. David, your recommendation would be to go to the applicant and then back to the public at this point?
Yeah, unless you have other questions for...
Okay, we have questions first from the board. Yeah, go ahead, Etan.
Yeah, Mr. Chair, since we voted on the ability of the intervener to present, I think the counsel for intervener should be able to speak longer than 3 minutes.
We didn't agree on any of that.
Yeah, we did not.
This is a new application. There's no interveners.
Yeah, there was no intervener status.
Okay, so let's just rewind. Before the last meeting that they came in here with, I believe Mr. Green filed for an intervener. Am I wrong?
I did.
Yes, but that was a different application.
No, that's for this application. That was for this application. So what this board has to determine is, have they presented any information that, let me dig out my notes here. Have they presented any information that demonstrates that there is harm, because this is what's required under the intervener statutes and determined by the courts, that there is reasonably likely damage to the pollution or destruction of the public trust and natural resources at issue. So if they've presented any information that demonstrates any of those things, then you would then vote to say, yeah, you're a legitimate intervener. If they have not done any of that, you can take a vote this evening and eliminate the intervener status, and they can go sit in the audience as a regular audience member.
Okay, so just to be clear, this is not in our agenda that there was an intervener request. There was for last application. I did not hear that they were, our vote last time was to have a public hearing, and then they would be like anybody in the general public. So let me finish. So if in fact they've given us material and we can determine whether they have intervener status with the motion right now, is that correct?
That is correct.
Okay, so that's what I'd like to do. I'd like to hear a motion to see if they have intervener status.
Mr. Chair, they haven't finished presenting their case. How can we make a motion before they finish presenting their case?
How long is that? Is this like multiple days?
No,
or what
no,
is the
no, no,
standard?
no.
What is the standard?
The standard is, first of all, have they presented anything ahead of this hearing to support an environmental impact?
Okay.
The operative words are ahead of this hearing. No, we're not here to have that hearing here tonight.
No, they can also present information at the hearing. I want to make it clear, because there's, I think, some confusion, that this is not a new hearing tonight. This was determined by the board 2 meetings ago, that the board took a regular CAM application and by vote made it a public hearing, because that's what you did for the last one. So that's how we got here tonight.
But there was no request for intervener status.
It was part of the application. It hasn't been talked about, but that is that's the road for him.
So then, am I permitted to allow the potential intervener to address environmental concerns and only environmental concerns?
As an intervener, that's why they're supposed to be here.
Okay, so anything about lot size and about pre-existing...
That's regular testimony that anybody else can give.
Okay. All right. So that's what I'd like to do. I'd like to give it back to this presenter and limit his information to intervener-related stuff, which is environmental impact.
So the CAM application cannot be granted because the site is not zoning compliant. That's item 1.
Mr. Chairman, I'm sorry, point of order. And I don't, and
Yeah,
with respect to Attorney Green, and I know I'm going to get an opportunity, but I anticipate that you're going to hear the exact same comments you've already heard.
No, I get it. Yep.
So, I mean, if out of respect for the board's time, the intervener petition should have been, he should have led with that information and brought an environmental expert to put evidence into the record.
Right.
So.
Intervener status was new to me just a minute ago, so I thought it was just out of our grace. We allowed it to be a public hearing, which would let them speak.
Right.
Okay? So now we're in a different world, and I'm told that...
I understand that, but it wasn't new to the intervener.
Okay, well now we're going to make it very specific. You're allowed to speak on and present evidence on the environmental impact only, not about who owned what and what we're allowed to do or not do. Please.
Thank you, Mr. Chairman, and I respect the commission. I respect your time, and I respect the rulings of the chair. I understand that I am not going to be allowed to speak to the application any further other than on the intervention. Is that the position of the board at this point, of the chair?
Thank you.
Is that the position of the chair?
That is the position of the chair.
All right. I have questions for the engineering consultant for the applicant.
They can ask questions as part of the hearing to make their case.
Okay.
But at the same time, they have to present information to spell out why they're intervening in accordance with the statutes and previous legal rulings.
Respectfully, and again, respectfully to Mr. McKenna and Mr. Green, if there was an environmental claim, they should have an environmental expert with them to present testimony, not utilize my client's expert to see if they can trip him up with some questions, totally unknown that he was going to be asked questions tonight. The last time they filed the environmental petition, as soon as they got their public hearing, they withdrew it. So obviously, they don't think there's any environmental concerns. So I think that if they're going to ask Ron questions, they should present some evidence that there's some environmental issue that Ron should respond to, not dig around Ron's brain to see if there's something that they think that they can then latch onto.
Yeah, I'm extremely uncomfortable with the way this is going, to be honest with you, and I would prefer that we table this and get an opinion from the city attorney on where we're going. I don't like any of the options in front of me unless we have a motion from the board to do something. I don't feel comfortable here at all.
I respectfully, and you should ask the city attorney for an opinion about whether it's a building lot as well.
Mr. Chair, I'm not in favor of tabling it right now. I think that the intervener has to present to us, the attempted intervener, specific materials, and he's done nothing tonight. We provided the same things, and I think to say that, to ask the individual who gave the opinions of my questions, it's not appropriate. You know, we're not getting anything that's letting us work appropriately, and just to table it assists the possible intervener and really impacts the applicant. This matter's been on for at least 2 to 3 weeks. I know it made one of our calendars, and the council has put in hundreds of pages for the attempted intervener, and there's a document from Mr. McKenna, but there's nothing we have tonight. And I don't think it's appropriate to keep continuing this matter to say, well, let's see what we can come up with. I mean, they were supposed to be here tonight. They asked for continuance, and the documents we've seen in mid-October because they didn't know about the agenda, so we're here tonight. We're ready to go. Where's your materials? If you don't have it, I think that you didn't have it to start with, and we should just say you didn't meet your burden, and we go from there. But my point is we should not table it tonight. We should deal with that issue. That's my point.
Any other thoughts?
I agree with Mr. Sadi.
I agree with Mr. Sadi. We haven't even established that this guy's an intervener. We've already given him way more time than we give the general public. I think we've met all our burdens, and he hasn't met any of his.
Well, I'll hear a motion.
So the motion we'd have to make, as I understand it through the chair to Mr. Sok, is we have to make a motion in the affirmative.
Yeah, all motions are in the affirmative.
All right, so I make a motion in the affirmative that the intervener has not met his burden of proof on establishing his status under General Statute Section 22A-19, and that he's presented no evidence to this particular board regarding any concerns regarding the coastal areas and also the activity regarding the coastal waters. So my motion is to affirmatively indicate that he's not met his burden.
I think what David said is you want to make the motion that we grant intervener status, and then if it fails, then it doesn't.
That's correct. Make a motion to grant intervener status. If it fails, it doesn't. Thank you.
We have a motion. We have a second.
I will second.
We have a motion and a second. Is there any discussion on the motion?
Yes, sir. So as I indicated before, under the general statute, it's come up a few times, but most importantly, we've had no evidence whatsoever, and I questioned specifically Mr. Wassmer and also Mr. Wicko on said issue. It has nothing to do with whether it's a building lot or not. That's a different issue. They did not meet any burden whatsoever. There's not a single document in the hundreds of pages that I'm suggesting. I think one is 60 pages, maybe 100, but a lot of documents, and it's appropriate. We've had documents given today. Nothing shows it anything to do with the coastal resources. All are consistent with the issue of it's not a building lot. And I do recognize at one point in the narrator's comment, I'm trying to find the pages in there, he makes an allegation, and that would be Mr. McKenna's narration of it. Makes an allegation, but it's never supported by any evidence. As a matter of fact, the evidence in the record right now is refuting that completely, as I asked the two experts from the applicant. So I'd ask you to deny this particular motion. He's not met his standard. As a matter of fact, we have no evidence whatsoever that he's even come close to meeting it. Thank you.
Thank you. Any further comments from the board? Seeing none, this motion is to grant intervener status. If you're not in favor of that, vote negative. Please call the roll.
Mr. Agnesi.
Against the motion.
Mr. Anderson.
I'm against the motion.
Mr. Hirsch.
Against the motion.
Mr. Collegian.
Against the motion.
Mr. Mortimer.
Against the motion.
Mr. Sadi.
Against the motion?
Mr. Zaharidis.
Against the motion.
Chairman Quish.
I'm also against the motion. Intervener status has not been established.
May I be heard on the application itself?
After his rebuttal, you will have 3 minutes.
Thank you, Mr. Chairman. Good evening. Just briefly, and I know the board's heard this several times already, but the Artses and Attorney Crusaden didn't determine this was a legal building lot. Mr. Sulkus determined it was a legal building lot, and Mr. Harris determined it was a legal building lot. And it is relevant that they made that determination because the Artses then went forward with these applications. And respectfully to this board, you have a lot of authorities, legislative authorities, but you do not have the authority to overturn those decisions, regardless of what Attorney Green says about that. That is the case. You can't overturn the zoning officer's decision, which have been repeatedly that it's a legal building lot. Yeah, there was a tent application. I didn't bother the board with that because, I put in the pavilion building information. In Milford, and it's not just in Milford, but the way it's interpreted, if it's a building lot, it's a building lot. And for whatever use is allowed in that zone, you can build it as long as you can put it on the property, regardless of the size of the lot. From the neighbors, there was no comments that the property or project is not zoning compliant. There was no comments that there was any coastal, or evidence that there was any coastal adverse impacts to coastal resources. The project has been vetted by the city engineer. I believe the fire department looked at it, and we have all of the municipal approvals. Thank you.
Thank you. Any questions or comments from the board at this time? Okay, seeing none, you will be afforded 3 minutes.
Thank you, Mr. Chairman. And once again, I want to thank the board for your patience. Not all building lots are, quote, building lots, as Attorney Crusaden suggests. Not all lots are building lots. Residential building lots. You can't build a home on every lot. In this case, there is no decision of consequence by Mr. Sulkus or Mr. Harris, such as a building permit sign-off, a zoning permit, and that sort of thing. That would trigger an appeal to the Zoning Board of Appeals. That did not happen here. There is an opinion that was preliminary. That CZR is the gateway to this commission, or this board rather, reviewing site plans. That didn't happen. In this case, that is not appealable. It is not a decision of consequence under the law. So there was no reason to appeal that, and the fact that council had meetings with them and then published it in the paper does not trigger an appeal. It sets a terrible precedence for the public to hear that you can have private meetings with zoning staff, record something in the land records, and suddenly that opinion binds this commission, forecloses my client from taking an appeal. It has to be a decision of consequence. There's a process under Section 7 of your zoning regulations where this commission, this board, decides site plans and interprets site plans. There are times when Mr. Sulkus can make certain decisions on building permits or sign off on building permits, violations. The zoning enforcement officer can sign off on violations. Those are decisions that are appealable because they are of consequence. Here, all you have are some opinions, and the fact that council published those in the paper does not bind this commission. And under your regulations, this is not a decision that this board would make anyway. So there is basically a site plan review before you as part of this coastal review. And we've demonstrated that the lot is only, the proposed parcels are only, or merged parcel, whatever you want to call it, is only 50 feet wide. It only has 5,000 feet. It doesn't meet the zoning regulations. The burden is on the applicant to somehow show that a non-conforming lot is a building lot, and that has not happened here. And as we argued in the past, it has to be zoning compliant for you to find that it is CAM compliant. I would ask the commission to incorporate, I know that council made reference to the original application. That application was before this commission was approved. The previous application, the CAM application that was denied, that is on appeal, and you'll bear with me, it was the application filed on December 15, 2023. It was denied by this commission, or the commission did not approve it, in April of '24. References have been made to the record. In that case, I think that the commission, the board should incorporate the record from the previous application into this application because it's been referred to by council. I think I've referred to it. So I would ask that the board incorporate the record from the last application. And I won't take up any more time.
Thank you. You do have the final word?
Thank you. I just want to, the insinuation is that something secretive went on with confirming these were legal building lots with staff. And that's why we published notice of it. So I just want to point out that is the process. They did make a decision. It was published. It was never appealed. That's what's allowed under Connecticut law. And they've also made the decision as part of this process. David Sulkus certified it as zoning compliant as well, and that was not appealed. Thank you.
Thank you. Okay. Without objection, the public hearing is closed. Okay. Any discussion on the application, or somebody want to make a motion?
Mr. Chair, Mr. Kalichi, you can make a motion.
Thank you.
I'm going to make a motion to approve with conditions. The petition of Kevin Kerseiden for a coastal site plan review for a single-family dwelling on map 45, block 513, parcel 39, of which Brendan Arts is the owner. My modification is that the approval have the condition that the newly placed fill at the end of the downspouts and the parking area be tested for compaction, for infiltration, to confirm that the hydraulic conductivity meets the recommendations of the 2004 Connecticut Stormwater Quality Manual between 0.03 and 5 inches per hour.
We have a motion and a second. Any discussion on the motion?
Chair.
Yeah.
Thank you very much. I support fully Brian Collegian's motion, and I think that the issue we have in front of us is that for the record, October 21st, 2024, documents provided by the applicant on page 19 and page 23, there's a building permit and a zoning permit that was filed with the city. We do have the administrative summary indicating that this is a CAM application, is zoning compliant pursuant to the assessment of Mr. Sulkus, and also there is contained in that document an opinion from the city attorney. So I find that it is zoning compliant. I suggest that we should accept that particular document, which we have from Mr. Sulkus, that it is zoning compliant. I'm going to be voting in favor of this particular motion by Mr. Collegian.
Thank you. Any comments from the board? Seeing none, I would please call the roll.
Mr. Agnesi.
With the motion.
Mr. Anderson.
With the motion.
Mr. Hirsch.
With the motion.
Mr. Collegian.
With the motion.
Mr. Mortimer.
With the motion.
Mr. Sadi.
With the motion.
Mr. Zaharidis.
Against the motion.
Chairman Quish.
I'm against the motion.
The motion passes.
Okay. Thank you, everyone. Next order of business is liaison reports.
None. We have our next meeting, a meeting next week.
Subcommittee reports, we're going to have a Zoom subcommittee meeting on what date, David?
Give me 2 seconds. I believe that is, well, it's next Wednesday. So that is Wednesday the 13th.
Okay, so that will be a special meeting.
That'll be a special meeting. You and I have to get our heads together about what exactly you want on that agenda.
Understood. Okay. Approval of the minutes, 9/15/24, 10/15/24. motion? We have a second? Without objection, minutes are approved. Chair's report, in your package, you have 4 items that are to be circulated. They are each just conforming with the state regs. Would you actually make that statement, David?
Yes, these changes are being proposed to bring us into conformance with state statutes.
Okay, so that will be, they will be circulated. When they come back, we'll have a public hearing to codify that.
Mr. Chair, that would be all 4. That'd be going to be, all 4 is going to be circulated to these.
Yes, that's right, yeah. Okay, staff report.
You should have in your package the proposed 2025 meeting calendar. I would like you to vote on it tonight so we can get it to the city clerk in time for next year.
Are they first and third Tuesdays?
They are every month except November. November 5th, to be exact.
And why is that?
That might be the election day next year.
Ah.
So,
I thought we weren't going to have any more elections.
well, we'll find out between now and next election day.
Okay, very good. I'll hear a motion.
Make the motion.
A second? Okay, affirmation. All those in favor? Opposed? Seeing none, motion passes. Okay, thank you very much.